should be on. Yeah. That's it.
Thanks very much, Shireen. Okay, welcome to those in attendance at this remote meeting of the local review body of Aberdeen City Council on Tuesday, the 20th of April 2021. Please note the meeting will be recorded and published online for public access after the meeting. Can all members leave their cameras on but mute their microphones when not speaking? The microphone should only be switched on when you're invited to speak. Guidance on how to do this is contained in the guidance issued to you. I will now ask the clerk to advise the members participating today and for all members to confirm their attendance once their name has been announced by the clerk, so that it's clear in the recording of the meeting and can also be recorded by the clerk for the minute. As the local review body contains quasi-judicial business, members are reminded that they should not leave the room or meeting during the consideration of any of the applications. Could I ask Ms. McBain, please?
Thank you, convener. So I'll just do a quick roll call for the recording. So just please state that you're in attendance. Convener?
Here.
Councillor Cameron?
Here.
And Councillor Reynolds?
Here.
Thank you.
Okay, thanks, folks.
Sorry, just to say as well that all three members are here for both items rather than switching over. Okay.
Perfect. Ms. McBain. This meeting has been convened in the response to one request for a review of a decision taken by an appointed officer under this council scheme of delegation, and also one request due to a non-determination of the application from the planning authority within 3 months period. Members of the local review body have before them copies of the review documents as listed in the notice calling the meeting. I will now turn to those applications. So turning to the consideration of the first review, with respect to the decision to refuse the application for the detailed planning permission for the formation of a dormer to the rear of at 28 St John's Terrace, Aberdeen, application 201622. We'll now hear from the planning advisor, Mr. Gavin Evans, who will provide us with a brief description of the application proposal and a reminder of the reasons why the application was refused. I would point out that Mr. Evans attends today's meeting to provide us with the necessary professional guidance because he has not been involved in the earlier consideration of the application under review. Mr. Evans, however, will not be asked to express any views on the merits of the proposed development, and in effect, his role will be a neutral one, involving the provision of factual information and guidance only. And with no more ado, I'll hand over to Mr. Evans.
Sorry, convener, sorry to interrupt the proceedings. I'll just do the statement as well.
Oh, yes.
That's okay if I'll just do that just now before Mr. Evans comes in. Okay, so thank you. Members have the procedure note which was circulated with the meeting papers and is intended to set out the wider framework within which the review process operates. From this, it is clear that the first task for the review body is to come to a decision on whether the review documents contain sufficient information for the case to be determined without further procedure, and by that it is meant without further information or representations. To assist, I feel it would be helpful to mention the following. Firstly, that the regulations governing the local review process require that all matters which the applicant intends to raise in the review must be set out in or accompany the notice of review. Secondly, that the focus of the review should be on the basis of what was before the appointed officer when a decision was made, and only in exceptional circumstances will new or additional matters be permitted to be taken into account. And thirdly, to note that the modernisation of the planning system, which included revisal of the planning appeals process, of which this local review body is part, removed the previous right on the part of an applicant to insist on a hearing and replaced that with the local review body, providing them with the power to choose a procedure which more accurately reflects the facts and circumstances of the individual case. And lastly, that guidance issued by the Scottish Government's Chief Planner in 2011 stated that reviews by local review bodies should be conducted by means of full consideration of the application afresh. This review should take the form of a structured discussion led by the chairperson to consider the matter set out in the notice of review before you, and I would conclude by drawing your attention in particular to points 10 to 12 of the procedure note. Thank you.
Thank you very much, Mrs. McBain. I saw it and I just bypassed it. Sorry about that. Mr. Evans, could you take us into the application, please?
Thank you, convener. Yes, just share my screen with members here. There we are. Hopefully that's the right one, and you can see that okay. Just change that to full screen as well.
That's it. Yeah, it's there, Gab.
Perfect. Yes, so thank you, convener. So as you mentioned, the first case that we have before us today is an application for local review against the appointed officer's refusal of planning permission for the formation of dormer, a dormer window to the rear at 28 St John's Terrace, Aberdeen. The review was found to have been submitted with all the necessary information and within the time limit of 3 months following the appointed officer's decision. The applicant has indicated in this case on the notice of review that no new matters have been raised in these submissions, and in terms of the procedure by which the review will be conducted, the applicant has expressed the view that this may proceed based on the current written submissions without the need for any further procedure. I'll provide some background to the case before handing back to members to decide how you wish to proceed in terms of any further procedure. So just a quick site description. The application site is located on St John's Terrace, which is an inset road that runs along the northwestern side of North Teesside Road, just east of its junction with Springfield Road. The site comprises a substantial detached granite dwelling spanning two stories plus attic. The appointed officer's report refers to a single-storey extension along the width of the rear elevation, along with a centrally positioned conservation beyond that to the rear. Just flick through, this is just an image from the council's GIS mapping system, so you can just see the outline of that conservatory centrally positioned within the plot there. And that's an aerial photo as well. So the roof of the property includes 3 roof windows on the rear slope and 1 to the front. A single garage is located at the western extent of the site, which you can just make out there, accessed via an unnamed lane to the rear, which just comes off in this direction. The surrounding area is characterised by residential dwellings. It is notable that St John's Terrace is generally characterised by bungalows with dormer windows at first floor level, whereas the application property reads as a full 2-storey height to the rear. And you can see this perhaps more clearly in this image coming along southwards along Springfield Road. So the general character of properties is akin to that on the corner, and this one does seem a little bit larger in that streetscape. In terms of planning history, the appointed officer's report makes reference to 2 earlier planning permissions. The first of those, reference 141500, was granted permission in February of 2015 for the formation of 2 dormers to the rear of the dwelling, as well as the erection of a 1.5-storey outbuilding within the rear garden. That permission was not implemented and has therefore since lapsed. More recently, application 201192 was approved in December of 2020 for the formation of dormer windows to the rear. The officer's report noted that the approval came after some revisions to an initial scheme that the Planning Service did not find to be acceptable. So turning then to the proposal before us today, detailed planning permission sought for the formation of a flat-roofed box dormer on the rear elevation of the property. You can just see the site plan, which sort of doubles as a roof plan here. So this is the front of the property to the bottom of the slides, existing on the left and proposed on the right. And you can see the flat roof in orange there of the proposed box dormer to be introduced. And rear elevation shows it best, I think. So the elongated dormer comprises 3 glazed sections connected by slated linking panels. These 3 glazed sections correspond to a bedroom, shower room, and combined landing cum study area, respectively. Materials include slates to match the existing roof, a dark grey membrane to the flat roof of the dormer, black UPVC rainwater goods, so guttering, and white UPVC fascias and soffits. A 150mm lead apron is shown below the windows, so just that sort of small upstand that you can see there. This is just the side elevation, so you see the sides to the dormer, again finished in slate to match the existing roof. And just from the other side as well. existing and proposed floor plans of the upper floor, so you can see how that manifests itself in change to the internal accommodation. So at the moment this is annotated as a study cum playroom. The dashed lines here indicate the coombs or lions to the roof, so that space is obviously compromised to some extent in terms of its headroom. So the introduction of the dormer with the 3 windows along here allows for that to be sort of usable and meaningful headroom, and so allows for the creation of a new bedroom, shower room, and this landing cum study area. It's just a section through to illustrate that same point, really. So it gives you an indication of the relationship of the dormer roof to the ridge height. You'll see, as I mentioned, there's no real sort of solid section to the front of the dormer. There's just a sort of small lead flashing, really, which again you can just see there, the lead apron. So then, turning to the appointed officer's reasons for refusal, these make reference to the following factors. Firstly, that the dormer is not set an acceptable distance below the ridge line of the building, giving the dormer an unbalanced and uncomfortably high appearance on the roof slope, which is on a publicly visible elevation. The design, form and proportions were not seen to be sympathetic to the traditional proportions and architectural style of the house, therefore having an unacceptable impact on the character and appearance of both the dwelling itself and the surrounding area, taking special cognizance of its highly visible position when viewed from Springfield Road. The proposed dormer was therefore concluded to not have been designed with due consideration for its surrounding context, and therefore it was considered that it wouldn't comply with policy D1, quality placemaking by design, and H1, residential areas of the Aberdeen Local Development Plan, along with the relevant supplementary guidance contained in the Householder Development Guide relating to dormers. It was noted that the proposal would also fail to comply with the equivalent policies to the proposed plan, and no material considerations were identified by the appointed officer that would warrant setting aside the provisions of the development plan in this instance, so nothing that would outweigh that policy conflict. So turning then to the appellant's case, it's set out in the notice of review along with an accompanying statement, both of which are in the agenda pack. The following main points are made. Firstly, the dormer extension is required to provide usable floor space on the second floor of the property. Contends that the dormer would sit on a substantial area of roof slope and therefore would not dominate the existing roof. Considers that the design, form and proportions are sympathetic to the proportions and architectural style of the existing property, and suggests that due to the elevation above ground level, the relationship between the dormer and the roof ridge would not be readily visible from street level. Highlights also that a previous planning approval, 2011-92 from December 2020, permitted dormers which would be set at the same height on the roof slope, and I've just included an image of that on the next slide for comparison. So the top image here is what was previously approved in December of 2020, and then here we have the current proposal. So the main difference really is in the increased width of the dormer that's currently proposed and the introduction of these linking slated panels. But as the appellant mentions, the position on the roof relative to the ridge is looks to be identical. So turning then to, sorry, I don't have a slide for what I'm talking about here, but turning then to consultation responses, there was no response from the local Braeside Mannifield Community Council, nor were there any representations from members of the public. At that point, convener, I'll just hand back to you for members to decide if you feel any further procedure like a site visit is required. Thank you.
Thank you very much, Mr. Evans. You'll have noticed I did drop out, but I've gone onto my iPad, so hopefully everybody can hear me okay. Gavin, can I get you to take down your slide?
Sorry, yes, of course.
It's okay. Not that I really want to see myself in high definition. Okay, so members, we've heard from Mr. Evans. We now need to consider whether we have sufficient information in front of us today to take a decision on the applications. Members will note that the application has stated that no further procedure is required before determination. Members, remember that if you do feel you have enough, if you don't feel you have enough information, you can request for either further written information or we can arrange a site visit. Councillor Cameron.
I'm happy with the information we've got to go forward today.
Okay, Councillor Reynolds?
Yes, I think we've got sufficient information to carry it forward today. Thank you.
Okay, and again, I'm equally satisfied we have information that will allow us to determine it today. Okay, as members feel that we have sufficient information, we will now hear from Mr. Evans on the relevant policies and considerations of this review. Mr. Evans.
Sorry, I was muted there. Thank you, convener. I'll just share my screen again. There we go. So yes, thank you. Just turning then to the policy considerations relevant to this case. The application site is zoned within an H1 residential area in the Aberdeen Local Development Plan, so therefore policy H1 applies. This sets out a series of criteria for the assessment of new development, stating that proposals for new residential development will be acceptable in principle, provided that they firstly do not constitute overdevelopment. In this case, we're obviously not extending the footprint of the property so much as just into the roof space. Secondly, that they do not have an unacceptable impact on the character and amenity of the surrounding area. It's for members then to decide what you feel the character of this area is and the extent to which it would be affected by this proposal. Thirdly, proposals should not result in the loss of valuable and valued areas of open space. This is a domestic residential curtilage, so no public open space would be affected at all. And lastly, proposals should comply with the relevant supplementary guidance. In this case, the relevant guidance is the Householder Development Guide, which includes some quite detailed specifications for the design of dormer windows. So we'll just come on to that next. So that document firstly sets out some general principles to be followed, and then offers up some more specific criteria for dormers to the rear of more traditional properties. So starting with those general principles, proposals should be architecturally compatible in design and scale with the original house and the surrounding area. Materials used should be complementary to the original building. In this case, I think we mentioned that it would be slated dormer, obviously glazing, and UPVC windows and rainwater goods. Any extension or alteration proposed should not serve to overwhelm or dominate the original form or appearance of the dwelling, and should be visually subservient in terms of height, mass, and scale. No existing extensions, dormers, or other alterations which were approved prior to the introduction of this supplementary guidance will be considered to provide justification for a development which otherwise fails to comply. So essentially saying examples from 20 years ago aren't going to be held up as justification for something that doesn't comply here. New dormers should respect the scale of the building and should not dominate, overwhelm, or unbalance the original roof. And in terraces or blocks of properties of uniform design where there are no existing dormers, the construction of new dormers will not be supported on the front or other prominent elevations. As we saw from the street view images, dormers are a common feature of surrounding properties in the surrounding area, so it's not the case that they're an entirely alien proposition here. On individual properties or in terraces where there are existing well-designed dormers and where there's adequate roof space, the construction of new dormers which match those as existing will be acceptable. Additional dormers will not be permitted, however, if this results in the roof appearing overcrowded. New dormers should be closely modelled in their detail and position on the roof on the existing good examples, and would ideally be aligned with windows below. So moving on then to more specific criteria to the rear elevation of more traditional properties. Firstly, the aggregate area of all dormers should not dominate the original roof slope. In this case, the officer's report acknowledges and accepts the view that the proposed dormer would not dominate the roof space. Dormer haffet should be a minimum of 400 millimetres in from the inside face of the gable tabling. There's no gable tabling on this property, but in terms of a measurement from the edge of the roof, that's in excess of 1 metre on both sides, so it's comfortably satisfying that. The front face of dormer extensions should be a minimum of 400 millimetres back from the front edge of the roof, but not so far back that the dormer appears to be pushed unnaturally up the roof slope. In this case, the dormer would be set back at least a metre up the roof. However, the officer's report has expressed concern in terms of that then being pushed. I think the phrase here is unnaturally up the roof slope, so that it looks a bit unbalanced. Flat roofs on box dormers should be a reasonable distance below the ridge. Term reasonable distance is obviously open to interpretation. The report argues that the proposal fails to accord with this provision. It's at approximately 150 millimetres, so if you think of a sort of standard length ruler, that's 30 centimetres, so half of that, and concludes that it would be uncomfortably high on the roof slope and unbalance its appearance. Also notes the highly visible location on approach south along Springfield Road compounds that visibility. Windows should be located at both ends of box dormers, which they are in this case, with the slated panels in between. A small apron may be permitted below a rear window. There's no slated apron in this case, just a small lead flashing, which is a sort of necessary construction detail. So there's nothing overt there. Solid panels between windows and box dormers may be permitted, but should not dominate the dormer elevation. It's for members to decide whether you feel like those slated infill panels are dominant or over dominant. The officer's report stated that the solid panels, in their view, would not dominate that dormer elevation. And then from there, moving on to policy D1, which applies to all new development. Now, this requires development to be of a high standard of design, which demonstrates an understanding of its context and links to the essential 6 essential qualities of good placemaking, which are just listed here. So then, just in terms of summing up and decision making, just encourage members to consider firstly the zoning. Does this proposal satisfy the tests set out by policy H1? Would it have an unacceptable impact on the character and amenity of the area? And would it comply with the relevant supplementary guidance relating to dormer windows? In terms of design in policy D1, having regard for factors such as scale, siting, footprint, proportions, relationship with the original property and materials, do you feel like it's appropriate to its context? And ultimately just coming to a conclusion on whether you feel this complies adequately with the provisions of the development plan. If not, are there then any other factors that you feel override that in this particular case? Happy to assist with any questions, or in the event the members are minded to approve with conditions. Thank you, Convener.
Thanks very much, Mr. Evans. Right, members. Councillor Cameron, have you any questions for Mr. Evans?
Yes, I'd like a little bit of clarity. I'll just get the thing up here. Okay. On the rear elevations of what was approved last year and what is being asked for this year, the 2 dormers are at the same height. Would that be correct?
Yes, that appears to be the case, Councillor Cameron. If there is any difference, it's barely perceptible from the elevation.
Right. So looking at the bullet points you've just looked at in relation to dormers, the aggregate area of the dormer doesn't dominate. The officers agreed to that. The haffets being a minimum of 400 millimetres in, yes, we don't have haffets, but it's certainly okay where it is. The flat dormers should be a reasonable distance before the ridge, below the ridge. There isn't a specific distance there, but the dormers last year were approved at the same height, so presumably that shouldn't give us a problem. Windows at both ends, yeah. And the last thing in relation to this was that if you look at the page 22 diagram, the proposal is more central to the windows underneath than the proposal that was approved last year. Is that correct?
Sorry, Councillor Cameron, is that page 22 of the agenda pack you're referring to?
Yes,
there?
sorry, Gavin, yeah.
Bear with me just 2 seconds while I get into that. Sorry, I'm just displaying my PowerPoint separately with a PDF. So yeah, sorry, I was looking at the same image anyway.
I know.
Just wanted to double check.
I'm cheating. I've got my mod.gov up at the same time.
Yes. So based on that sort of elevation of what we've got in front of us and what was previously approved, it looks like the current proposal is, broadly aligned with the windows on the lower floor. I think you could argue the previous approval was as well. So,
other than one of them was offset.
Yes, just slightly.
Okay. No, I think that's okay for just now, convener. Thank you.
Okay, thank you, Councillor Cameron. Councillor Reynolds, have you any questions?
No, I don't think so. Councillor Cameron's covered most of the points. I really can't understand, though, if the approval was given for the 2 dormers there at the same height as the current one, why the officer would actually be objecting to that within his refusal recommendation. It does look, without an accurate measurement, it looks identical to me. And as Councillor Cameron says, it looks far more balanced now than it did with the 2 separate dormers.
Okay, I don't know if Mr. Evans, Mr. Evans, I think did you not mention that they were set at the same height to the roof ridge?
Yes, just from looking at the elevations, it certainly appears to me that they're set at the same height. I haven't taken a measurement from the previous approval, but there certainly doesn't look to be any sort of, difference that would be perceptible from ground level anyway. If there's anything in it, it's very, very minor indeed.
So just for clarity, I think the major difference, Mr. Evans, is the infill section, which didn't exist in the previous, which gives you and it's slightly longer in terms of the length across the roof. Would that be a fair submission of the difference of the 2?
Yeah, that's right.
Okay, all right, thank you. Members, any further questions for Mr. Evans? No. Okay, well, we have before us, so I think in accordance with the procedure note, we will now discuss and decide the manner in which to proceed, which we've done and which is to determine it. I would highlight that all representations relating to the case have been considered and taken into account. So do you feel you're in a position to have a determination? Yeah. I suppose I'll kick off maybe to start with. For me, I believe that we've got a previous approval, which for all intents and purpose is very similar to the one in front of us. Apart from, as I earlier indicated in my questioning with Mr. Evans, is we do have an infill bit which is allowed under the supplementary guidance. We've got a slightly elongated window, a set of windows now, as opposed to it was slightly more determined with 2 separate ones. For me, I don't think it has an unacceptable impact on the character or amenity of the area. I think we heard from Mr. Evans in his sort of summing up of the application that they're not something that's new to the area, that there are dormer windows to the rear of many properties. And I think on balance, I'd be overturning the officer's recommendations and seeking any relevant conditions from Mr. Evans. Councillor Cameron.
Thank you, convener. I should be unmuted now.
Yeah.
I would concur with what you're saying. I'm looking at the moment on page 32 of the agenda pack, which are the summary paragraph for the reason for the recommendation, and I don't see that this it not being set an acceptable distance below the ridge line, especially in the light of the previous determination of the 2 dormers, which seem to be okay. The design and proportions, I think, are sympathetic. We're speaking about the traditional proportions and architectural style of the house. If you look at these pictures, the house itself has on one end a gable end, and on the other end a hipped roof. It's not proportionate itself. Being highly visible from Springfield Road, yes, I couldn't disagree with that. I know the area quite well. But that's almost coincidental rather than anything else, and it is a rear elevation. I just feel that I can't understand why the officer overturned I'll rephrase that. He hasn't overturned anything, or she hasn't overturned anything. The previous approval late last year, and this, what is effectively an amendment, I just can't see why this one was turned down. So I would be wanting to go with yourself, convener, and give approval to this application.
Okay,
thank you.
Councillor Campbell. Councillor Reynolds?
Thank you, convener. Yes, I think everything's been said on this. The only concern that I would have had looking at the plans originally was the solid space between the windows. But as they're going to be slated, it does actually tie in very, very nicely with the slates on the roof itself. And it does look far more balanced on the original proposal that was approved last year. So I'm more than happy to support the overturning of the officer's decision.
Okay, thanks very much. Again, just for completeness, so we've got a verbal record, I'll just get Mrs. McBain just to ask us individually. Mrs. McBain, could you just?
Yeah, thank you, convener. So just for confirmation, members are overturning the officer's recommendation to refuse and approve the application. Is that right, convener?
That's right. I've just asked Mr. Evans, is there any recommendations in terms of conditions that you would apply?
I don't think so in this case, convener. The materials to be used and the design seems to be fairly well specified on the drawing, so I don't think there's any question marks lingering.
Okay, that's perfect. Okay, thanks. So with that, we have agreed to overturn the officer's recommendations. Thank you very much, members. Right, we're moving now on to the, excuse me, just get my piece of paper. If we are now turning to the consideration of the second application in respect of a non-determination of the application for detailed planning permissions for the erection of a detached house, change of house type, plot 2, approved planning reference 170395 at Burnside Poultry Unit, Clinterty, Aberdeen. We'll now hear from the planning advisor, Mr. Gavin Evans, who will provide us with a description of the application proposal. I would again point out that Mr. Evans attends today's meeting to provide us with the necessary professional planning guidance because he's not been involved in any earlier consideration of the application. Mr. Evans, however, will not be asked to express any views on the merits of the proposed development, and in effect his role will be a neutral one involving the provision of factual information and guidance only. And I would say, members, this is quite an unusual one that we very, very rarely see. So perhaps, Mr. Evans, you could maybe just give us a little bit more detail about the reason it's not a refusal, it's a failure to determine as well. That'd be helpful. Thank you.
Yeah, absolutely, convener. I'll just share my screen again here entirely. So hopefully everyone can see that there.
Yeah, that's fine, thanks.
Right, yes, so in this case, convener, what's been sought is an appeal against the appointed officer's failure to determine the application within the statutory period of 2 months. That 2-month period applies to all applications in the local category, so not hitting thresholds to be major. So it's things under 50 houses or under 2 hectares of site area, that sort of thing. So it encompasses quite a lot of applications. The 2-month determination period can be extended by agreement between the planning authority and the applicant. However, if no agreement is reached after 2 months, the applicant has the right to appeal against the appointed officer's failure to determine promptly, and that then brings us to the local review body. So really, we're simply here today because the appointed officer didn't take the decision within that 2-month period, and the applicant has opted to use that right that's available to them to have the LRB consider the case. So really, we're considering things in just the same way as we otherwise would with an appeal against refusal. However, we don't have a decision to refer to, if you like, so we're still just going through the case in terms of the relevant policies and everything like that. And we have as well a report that was prepared for the LRB by the case officer to give an indication of what the recommendation would have been if they had been able to do that, or if the applicant hadn't submitted the notice of review. So that's a bit of background. I'll just sort of move on, and if you have any other questions, I'd be happy to assist.
Thank you.
So in this case, as I mentioned, we're considering review against the appointed officer's failure to determine an application within the statutory period of 2 months. Members may have noted that there was a typo on the first slide of the presentation as it included in the agenda. So I've just corrected that in this case, and apologies for that. So this relates to the erection of a detached dwelling house, and then in brackets, it's change of house type of plot 2 of the approved planning application, reference 170395 at Burnside Poultry Unit, Clinterty. So in as much as this is still an application for a new house and we are treating it on that basis, and the planning authority would be obliged to treat it on that basis, the only difference from what was previously approved by the LRB back in 2017 is the addition of essentially an extension or an additional bit of ground floor space to that property. So it's really just changing that minor thing. So the review was found to have been submitted with all the necessary information and within the time limit of 3 months following the appointed officer's, sorry, I'm reading pre-prepared speech there that doesn't make sense here. The review was found to have been submitted with all the necessary information and within the appropriate period following the 2-month determination period elapsing. The notice of review advises that no new matters, i.e. matters that were not before the officer at the time of consideration, have been raised in these review submissions. Members will note that a significant amount of information has been submitted along with the notice of review. Many of these documents didn't form part of the application itself, but would nevertheless have been before the appointed officer, having been lodged separately in relation to the earlier decision by the LRB. So that 2017 decision was subject to various conditions, and the applicant would have been obliged to make further submissions relating to those conditions. So providing that documentation along with the review is not really raising new matters as such. And on that basis, we're not, I wouldn't recommend that members treat these as new members. Similarly, a tree survey that was submitted by the applicant, which is referred to as item 16 with further comments following circulation of the appointed officer's report to the LRB, had already been before the officer in relation to conditions attached to that earlier permission. In terms of further procedure, the appellant requests that one or more hearing sessions are held, stating that it may be of benefit for the local review body to examine and discuss the merits of the application before them. We'll come back to that later, but members might feel that the ordinary discussion that takes place today is sufficient to deal with that. So a brief description of the site. The application site is formerly agricultural land located in open countryside to the south of Blackburn, close to the city boundary with the Shire. It was historically used as a poultry unit, but such agricultural use has been discontinued some time ago. There are a number of established trees on the site, which is accessed via a narrow farm track which joins at the B9. The application site's one of 2 adjoining plots where new dwellings were previously approved by the local review body. That's just the site outlined in red there. This is a much wider view just to give you a bit more context to where we are south of the A96 here. And an aerial photo just to go along with that. And zoomed in aerial photo there. So that's the plan as existing. In terms of planning history, planning application 170395 related to the erection of 2 detached dwellings and was refused under delegated powers, but that decision was subsequently reversed by the local review body in December of 2017. So that decision would ordinarily have a 3-year period for the consent, expiring in December of 2020. However, coronavirus-related changes to planning legislation introduced an automatic extension to consents that were due to lapse in what was defined as an emergency period. So that permission would now have been automatically extended until the 31st of March 2022. So just by way of context, that consent remains very much live and capable of being implemented. Sorry, I'm not sure if that red line is flashing on the screen. It's quite distracting. Not supposed to be doing that. In terms of the proposal, detailed planning permission is sought for a single detached dwelling house, accessed via the existing farm track from the public road. Plot 2 is the westmost of the 2 previously consented dwellings, and this application seeks permission for a different house than was previously approved on the plot. The proposed dwelling is largely identical to that was previously approved, spanning 2 stories and featuring a combination of smooth render. So this slide just shows it in context with the other approved house. Featuring a combination of smooth render and larch cladding to the walls. I'll come back and talk about the elevation separately. I'll just talk to these slides briefly. So on the left we have the ground floor plan as approved by the LRB, and on the right hand side we have the current proposal, which, as you'll see, basically adds on a little extension and extends the living area on that southern elevation. Similarly at first floor level, so this is just void space, there's not actually floor level there, you can notice a sort of balustrade there. So that's the north elevation, to which there's no change whatsoever. The south elevation, so in yellow here we have the extension, if you want to refer it to that, bearing in mind we're essentially assessing the whole house, but the difference is the extension and the introduction of a new window set there. And again, just in the east elevation, you see the further extension protruding out, 4-meter projection from the southern elevation. So in terms of materials, as I was saying before, walls featuring a combination of smooth render and larch cladding with a slated roof above. Windows and doors are timber aluminium clad in dark grey with the garage door of the same colour, and rainwater goods are in black UPVC. Foul drainage was shown to be provided via a private system, i.e. a septic tank, although members will note from conditions that a condition was applied to the LRB's earlier decision stating that a public sewer connection would be a prerequisite. What differs from the previous approval is the extended ground floor footprint with an additional 24 square metres of communal living area added to that southern elevation. The south face of that elevation, as we saw from the elevation here, is extensively glazed. So at this point we would normally go over the appointed officer's decision. In this case there was no such decision, no decision having been reached. The planning service has provided a report to the LRB indicating what its recommendation would have been had it not been for the submission of the notice of review. So again, this is just the other side elevation, sorry. So I'll just go through that briefly. Yeah, so firstly, notwithstanding the conflict with the Greenbelt policy and transport policies T2 and T3 in the LDP, the planning service recognises the existence of that previous approval, which is a significant material consideration and to be weighed alongside the provisions of the plan, and notes the minor nature of the changes to the house. So that policy conflict was not considered to warrant refusal of the application, and the Planning Service's recommendation would have been to approve subject to conditions. Now that's on the basis that the proposal was not felt to result in any significant intensification of use or change of travel patterns relative to the planning approval that we established remains in effect. The proposed revised house design was considered to accord with the Local Development Plan's policy D1, quality placemaking by design, and the Planning Service felt that conditions could be imposed to address the expectations of other Local Development Plan policies relating to trees and woodlands, flooding, drainage and sewer connection, design, landscape and energy efficiency and water efficiency. The recommended conditions, seem to largely replicate those that were attached to the earlier LRB decision. Those include the removal of domestic permitted development rights that would allow for further extension of the property without planning permission being required, a requirement to demonstrate a connection to the public sewer system, details of hard and soft landscaping. Conditions that were attached to the LRB decision in relation to waste storage and collection arrangements and investigation of potential site contamination have not been restated, or it's not recommended that they're restated by the Planning Service. This is understood to be on the basis that sufficient information was provided for the officer to be satisfied that that was no longer necessary. So turning then to the applicant's case here. The applicants have submitted a statement in support of the application for review, available in the agenda pack. Main points, there was also a further submission from the applicant in response to the publication of the Planning Services report. So there's a few things to go through here. First and foremost, the applicant contends that the application introduces a very modest extension to the previously approved house type, which came via that LRB decision, highlights that the original duration of that consent was extended by changes to legislation and therefore remains live, and it's accepted that that is the case. All pre-commencement conditions had been addressed prior to development being undertaken. So this is all really relating to the existing permission, so the extent to which it's relevant to your decision making is debatable. Demolition and site clearance works commenced in October 2020, and a validation report relating to site contamination was enclosed, confirming that contaminants had been removed and soil samples tested. A trench was dug for foundations in January of 2021, and photographs are enclosed to demonstrate that, therefore preventing expiry of the existing permission. The additional space proposed would allow for home working needs to be met, and it's contended that the application relates to a change of house type only, and therefore other matters need not be revisited. As I mentioned before, the planning authority is really obliged to consider the proposal in its entirety. It's effectively a new house with everything that comes along with that. The earlier decision to grant permission for a house on this site is of course a significant material consideration, but it's not simply the case that the planning authority would be considering only the extension and nothing else. So moving on to the next slide there, sorry. Specifically, it seemed unreasonable to the applicant that the Roads Development Management team initially expressed some concern regarding access and refuse collection arrangements when those matters had already been reviewed with no objections by the same team in the course of the earlier application. Highlights that waste arrangements in relation to the existing permission had been agreed with the Council's waste management team. And consultation with the waste team on the current application delayed determination of the application unreasonably. However, no concerns were raised in any case. Considers that the case officer's suggestion of new or additional conditions would be unreasonable in the context of the existing live permission, and considers that the case officer's request for drainage information during the course of the application was unreasonable when this had already been provided in connection with conditions attached to the earlier consent. This might seem a small point, but I think the issue here is that the applicant was being asked to provide information that they had perhaps already provided in connection with a different planning permission. But from the planning authority and the case officer's point of view, this is a new application and you would be considering it in its own right. So it might well be that that same document remains relevant, but it still needs to be provided to you either at the time of the application, or if not, then it would be reasonable to apply a condition to secure that. Highlights also that the case officer confirmed in correspondence that changes to the approved house design appeared to be non-contentious and did not appear to conflict with policy D1. Now that seems to be borne out by the Planning Services report to the LRB, which expresses satisfaction that the proposal is in accordance with policy D1. And moving on to this next slide. So this last slide summarises the points that came in following publication of the Planning Services report. So firstly, disputes the extent of the application site as described in the officers or the Planning Services report. Considers that conditions 2, 3, 4 and 5 as set out in the case officer's report to the LRV are unnecessary, and that it would be unreasonable and illogical to apply them to any new permission, given those matters were already addressed in connection with the earlier permission. And I think that's the salient point. They were addressed in connection with an earlier permission, so they still need to be satisfactorily addressed in relation to any new permission that comes from this process. No issue was taken with proposed conditions 1, 6 and 7 per the case officer's report. And should members be minded to grant permission, the appellant requests that the conditions applied to the earlier permission be adopted without the need for further submissions on those matters. So I think is effectively saying, yes, happy to comply with the conditions that were previously attached, but don't see why the documents that were already provided should have to be resubmitted to the planning authority. So, sorry, that's just onto policy, so I'll pause there. In terms of consultations, the Council's Roads Development Management Team ultimately had no safety objection, but advised that the development is likely to be car dependent due to the inadequacy of access to the site by sustainable transport routes. In terms of waste and recycling, the Council's waste team also stated no objection, advising that waste collection by wheelie bin should be from the public road, B979. There was no response from the local Dice and Stonywood Community Council, and there were no representations on this application from members of the public. At that point, Convener, I'd just hand back to you with a reminder that the applicant had requested that one or more hearing sessions take place, so for members to decide if you think that's necessary.
Okay.
I'll just close it. Thank you.
Okay, members, we've obviously heard from Mr. Evans. We obviously need to decide whether we have sufficient information in front of us today to take a decision on the application. Members are reminded that if they do not feel they have enough information to take the decision, you can request that the site visit be undertaken or further written information be provided, or that a hearing is arranged. Councillor Reynolds.
Just try. Yes, I've got it now. I think we've got all the relevant information that we need. A couple of questions when the time comes for Mr. Evans. Thank you.
Okay, thank you. Councillor Cameron.
Thank you, Convener. Yes, I would agree with Councillor Reynolds. I think, yeah. We've got enough. Thank you.
And likewise, I'm happy with the information we have to move forward today. Okay. Now that we've decided that we have sufficient information to take the decision, we will now ask Mr. Evans on the relevant policies, get the words out, in consideration for this determination. Mr. Evans.
Thank you, Convener. I'll just share my screen again here. You'll get tired of hearing me say that.
It's fine.
Okay, hopefully everyone can see that now. So yes, turning to the policy considerations, as we heard before, the application site is located within the designated green belt, where policy NE2 applies. This sets out that no development will be permitted in the green belt for purposes other than those essential for the, as listed here, agriculture, woodland and forestry, recreational uses compatible with an agricultural or natural setting, mineral extraction or quarry restoration, or landscape renewal. construction of new housing not listed in those. Policy NE2 does follow that up with a number of other specific exceptions, which allows for proposals for development within with existing activities in the green belt. So sort of small scale expansion of existing business premises, that sort of thing. Essential infrastructure, conversion of buildings of an architectural or historic interest. So that might be a steading conversion, for example, where there's a vernacular building, or replacement houses on a one-for-one basis. So you've got an existing house, knock that down, build a new house. So what it doesn't allow for is provision for new build houses on greenbelt land. Over and above that, NE2 also states that all proposals in the greenbelt must be of the highest quality in terms of siting, scale, design and materials. Following on from that, policy D1 applies to all development and requires that development is of a high standard of design, which demonstrates an understanding of its context and links to the following 6 qualities, being distinctive, welcoming, safe and pleasant, easy to move around, adaptable and resource efficient. Other policies include the following, so I'll just flick through these more quickly, I think. So policy D2 relating to landscape. Development should have a strong landscape framework which improves and enhances the setting and visual impact of the development, creates local identity and promotes biodiversity, should provide hard and soft landscaping proposals that are appropriate to the scale and character of the overall development. So again, really just seeking to ensure that development beds into its context as regards landscape and new areas of planting. Policy T2, managing the transport impact of development. This requires measures to minimise traffic generated, maximise opportunities for sustainable and active travel. As we heard, the Council's Roads Development Management team did not state objection, but did note that the location of the site is such that access is largely car dependent. There's not really much in the way of other options. Policy T3 relating to sustainable and active travel places an emphasis on encouraging active and sustainable travel, so walking, cycling, public transport. Sets out a need to protect existing links and form new ones where possible, and encourages car sharing, low emissions vehicles also where possible. Policy T5 relating to, NE5, excuse me, relating to trees and woodlands states a presumption against development that would result in loss of or damage to existing trees and woodlands of recognised value. Buildings and services should be sited so as to minimise adverse impact on existing and future trees, and measures should be taken for the protection and long-term management of existing trees and new planting both during and after construction. So applications affecting trees are to include details of protection measures and compensatory planting, that sort of thing. Policy NE6 relating to flooding, drainage and water quality. Development is not permitted if it increases flood risk elsewhere or would itself be at risk of flooding. There's no mention of flood risk being of concern in this case. Drainage impact assessments are required only for proposals of 5 or more homes, so not applicable in this case. And connection to a public sewer, this is perhaps more notable. Connection to a public sewer will be a prerequisite of all development where this is not already provided. Private wastewater systems in sewered areas will not be permitted, and in areas not covered by the existing sewer network, private systems will be permitted subject to demonstration that there will be no adverse effects on the environment or amenity, etc. Policy R2 relating to degraded and contaminated land sets out the framework for investigating and remediating past site contamination. The report provided by the Planning Service set out that they considered there was no longer a need for a condition to be applied in relation to contamination on the basis that that had been addressed. And policy R6 relating to waste management requirements. This states that all new development should have sufficient space for the storage of waste and recyclables, and details of storage facilities and means of collection must be included as part of any application for development that would generate waste. In this case, the Council's waste team stated no objection and were satisfied that arrangements could be put in place for bin collection. And lastly here, policy R7 relating to low and zero carbon buildings and water efficiency. This relates to reducing carbon emissions either through the use of domestic microgeneration technologies or through energy efficiency in the fabric of buildings. Also requires the use of water-saving technologies and techniques, for example, low-flush toilets or water butts in gardens, that sort of thing. Supplementary guidance documents relating to flooding, drainage and water quality, transport and accessibility, and resources for new development are also applicable. So just points to consider in coming to your decision, members. First and foremost, at principle, does Greenbelt Policy NE2 allow for residential development of the type proposed? The report provided by the Planning Service recognised that there is still conflict with policy in their view. However, felt that the presence of an existing planning consent that remains capable of implementation would outweigh that in this case. In terms of design, is the proposal of high design quality and appropriate to its context, consistent with policy D1, having regard for factors such as scale, siting, footprint, proportions relative to the original? You may wish to consider the extent to which the house differs in its appearance or style from that which was already approved. So ultimately coming to a conclusion on whether the proposal complies with the provisions of the development plan, but if not, are there any other material considerations that weigh in its favour? For example, in this case, the presence of that earlier permission obtained via the local review body. Happy to assist with any questions or to advise on conditions. Thank you, convener. Just back to you there.
Thanks very much, Mr. Evans. Members, questions. Councillor Reynolds, I'll ask you first this time.
Yes, thank you, convener. Mention has been made all the way through, excuse me, about this having been approved by the LRB. So I'm guessing the LRB had it on board because it was either a refusal or the applicant didn't agree with the conditions. When I first looked at this, and Mr. Evans, you could advise, when I looked at this, I thought this was just an addition. You know, it was an extension that was being applied for, but it's actually being taken as a brand new application. And as a layperson, I would have thought if it's a brand new application, you've already got the stuff that you need. Why would the applicant have to provide it all over again? Sorry, that's the first couple of questions, I suppose.
Thank you, Councillor Reynolds. Yes, you're quite right in terms of the scope of the application. I appreciate it probably seems a little bit inflexible or bureaucratic, but because the house isn't actually there in situ, what this represents in planning terms is just an alternative house on that plot. So we need to just treat it in the same way that we would an entirely new application. I imagine that's probably quite frustrating for the applicant in terms of providing information that they may already have provided in relation to that different consent, but procedurally they are two quite distinct things, and it's up to the applicant to put forward the submissions in support of their proposal. If you might argue that the applicant could sort of refer the council to those earlier documents, and the council, being reasonable, might, you know, refer to them and in the context of assessing this new application, but I'm not sure if that dialogue happened before the notice of review came in and things have sort of snowballed from there. But procedurally, yes, it is a bit of an oddity that somebody might have to submit things they've already provided to us, but the bottom line is that it's just because it's an entirely new application, so we need to just treat it on its own merits and take it from there.
Okay, another question, if I may. Excuse me. One of the advantages an officer looking at a new application is that technically it should speed the whole process up. And in this particular case, I guess that the planning officer had everything on board, had everything that he needed, but the delay came from the roads DM side, and that's why the hold-up. Would that be a correct assessment?
Yeah, I'm not sure how appropriate it is for me to get into, you know, the rights or wrongs of what caused delays, but it sounds like from the accounts we've heard, the roads position initially was unaware of the earlier decision by the local review body, and I think that may have contributed to taking a different position than might have been expected. So perhaps just different people being involved in those different applications, not knowing the history of things, has maybe led us to where we are today.
Yeah, I think, as you said, Mr. Evans, bureaucracy comes into that to a certain extent. Sorry, that's all my questions. Thank you.
Okay, thanks, Councillor Reynolds. Councillor Cameron.
Councillor Reynolds and I obviously think with one mind here. I don't have any questions left. Thank you.
I think we're probably all on the same kind of page in terms of understanding why. And I think it is one of the biggest frustrations that you hear from people is having to duplicate reports and because of time delays, etc. Can I just ask Mr. Evans, we've obviously been suggested to us by the applicant that we just pass over the conditions as I can't remember his exact wording. I think it was to adopt without the need for further submissions on these matters. Now, I'm a little bit confused as well in terms of the fact that, to me, it looks like the same house with a slightly large, with an extension on the front, and I understand why we've had to change that to a new application, whereas it's in some ways it's just like an extension to the house for us more lay members, I suppose, even though I'm on the planning committee. So in terms of being able just to kind of pass over, because I suppose it's not just as simply saying to them, you've got to make officers. It's just, are we expecting brand new reports to be established? Because obviously it's not then just time, it's also cost to the applicant. And if they've already gone through that process of getting a floods report and all the other conditions under conditions 2, 3, 4 and 5, is that something that the LRB, if we decided wanted to do, just to say adopt without the need for further submissions on these matters?
It's a bit tricky procedurally, I think is the easiest way to say it. I don't think it should be the case that the applicant would have to do much in the way of new studies or anything like that, because the conditions that were being discharged in relation to the existing permission, that was only done in, as far as I'm aware, the sort of middle to late part of 2020. So I don't think there's anything about those that should be inherently out of date. So it's likely that a lot of that information is equally relevant to the current proposal in terms of landscaping schemes and the like. So without having looked at it in full detail, I think the likelihood is that we should be able to accept a lot of that just simply being packaged up and sent to deal with any conditions that might go on this new permission. So it shouldn't be, unduly onerous in terms of additional cost or anything like that.
I mean, could we simply, rather than say adopt without the need for further submissions, just say to resubmit the previous reports? I mean, would that cover it? I'm just conscious that, I know of other cases, and I'm not speaking specifically about this, where people have had to spend tens of thousands of pounds on these reports, and to have to then go and get new ones done, is jeopardised, their ability to actually move a project forward. And in my view, looking at this quite simply, it is a minor variation to a current approval, and I wouldn't want to see us putting on unnecessary or over financially burdening the applicant to have to redo these all and cost them an awful lot more money and delay again.
Yeah. I mean, what we could do is attempt to frame conditions in such a way that they refer to submissions that have come in for the existing consent. What I'm not sure is of the legality of that in terms of referring to something that's not before us as part of this application, because they are two distinct things procedurally. So maybe have to ask for the advice of our legal advisor a little bit on that point.
Yeah. Are you there, Karen?
Yeah. Yeah, I'm here. I'm not totally sure what would happen here. I think if you're referring to a previous permission, it's possibly could be okay, as long as it was referred to properly in the conditions, like that you're taking in previous submissions. I could check though and come back to you if you don't mind.
Okay, well, what we can do, I don't know, Karen, do you want to?
I'll pop off and go and check. Thanks.
Yeah, okay. And we'll carry on at this stage and just make sure if there's any other questions. Has anybody got any more questions for Mr. Evans? No? Okay. Okay. Sorry, Councillor Cameron.
Mary. Yeah, I'll take my hand down now. I thought you were really good in this. It was really kind of supplementary to what you were asking about. And Mr. Evans indicated that because of the timescales, these reports should probably be valid. And my question really was to sort of clarify that. The current approval that they have now runs until next year.
Yes.
If they have submitted reports in relation to the cleaning up of the land, for example, the use of mains sewage as opposed to septic tanks and so on, all the things that there were conditions in the previous application, these reports would, by the very nature of the current application or the previous application still being live, would still be relevant, wouldn't they? We wouldn't be going back to them if they hadn't put this in, and they have put all these reports into planning for the conditions and chose to do absolutely nothing until 2022, but started then, we wouldn't be asking them to come back with other reports, would we?
No, you're quite right. They would be free to continue with the implementation of the permission, and in fact, over and above the expiry of the permission being extended until next year, the applicants having taken photos of themselves digging a trench for foundations means that it wouldn't expire in any case anyway. So they would be free to
assuming these reports are there and already been submitted, they're still going to be valid.
In perpetuity.
Yeah.
Effectively, because they've been submitted and already discharged the condition, so there's no further action required on the applicant's part.
Yeah. So the only reason that we are, well, we're waiting for Karen to come back, but the only reason that we would be looking at whether or not we put conditions in, assuming we were of a mind to grant the permission, would be to ensure that these reports were linked to this application, because this application is a new application. Yeah,
that's right. Yeah, I mean, it seems like a box ticking exercise, but essentially it is that link, as you say, that's the important thing.
Yeah. No. Thanks for that. Thank you.
Okay, members. Okay. Well,
Murray, could I ask just to follow up on it? It's really taking up what Councillor Cameron was saying there. The conditions 2, 3, 4, and 5. I've had a quick look through the paperwork. Can't see what they are, or can't find them. I'm guessing that one of those conditions would be to remove the poultry hot shed, whatever it is. And of course, to get to where they are at this minute in time, the shed is no longer there.
Can maybe pop up the conditions? We can have a quick look at them while we're waiting for Karen, if that's okay.
Sorry, I couldn't find them. My apologies.
Yeah, no, there's quite a lot of paperwork. I did a quick scan through mine as well.
Sorry, just bear with me a couple of seconds here.
I have got them actually.
Gavin, I can share it if you want. I've managed to find them.
Oh, thanks. That would be great, Lindsay. Sorry.
I just didn't want to read it out because I do have it in my hand. There you go.
So these are the conditions that have been recommended by the Planning Service in their report to the LRB. So these aren't a facsimile of what was on the LRB's earlier decision, but they're very similar. I think I mentioned that there are a couple that have dropped off, one referring to the site contamination and another relating to waste and refuse arrangements.
Basically, what we're hearing from the applicant is that he's already provided the information to purify these conditions. Is that correct? On the existing planning application, as opposed to the new one?
Well, he's certainly already provided the information to deal with the conditions on the existing consent, and because these largely replicate those conditions, he will have provided relevant information. So it's just the difference, if any.
Yeah, and he hasn't disputed with conditions 1, 6, or 7. That's what I've got his case. So he's got no issue taken with the proposed conditions 1, 6, and 7 as per the case officer's report.
Yeah, so 6 there is about the removal of existing buildings, residential caravan, areas of hard standing and farm equipment, etc. And number 7 is relating to the removal of domestic permitted development rights. So that's essentially meaning that further extension would necessitate a planning application. You couldn't do it as permitted development. And Lindsay, could you scroll up to number 1, please? So, okay, number 1 is relating to the sort of energy efficiencies and microgeneration side of things, which will be that would potentially be slightly different with the revised house, because that necessitates sort of calculations on the efficiency of the building being done. So that's one where there may be a requirement for an updated submission, if you like.
And to be fair, he said he's no issue with that proposed condition. So it's 1, 6, and 7 that he's content with. It's the others that he has a concern that he's already provided the information.
Yeah, so number 2 there is relating to the extent of car parking, surfacing, and vehicle turning areas. To my knowledge, those haven't changed. It's only the extension being introduced, so those should remain applicable. Number 3, drainage impact assessment, demonstrating SUDS measures. Again, if that was on the original consent and information's been supplied, then there's no reason to believe it would be dramatically different or not applicable to the current proposal. 4 is an important one, connection to the public sewer system. So that requires a scheme. So presumably a scheme was provided in support of the LRB decision. So I can't see why that wouldn't remain applicable and couldn't just be referred to in any reframed conditions here. And number 5 there, it's just details of soft landscaping and any new planting, I think.
Yeah.
As well as sort of protection measures for existing trees, kind of thing.
Okay. All right, thanks, Gavin. Is that helpful, Councillor Reynolds?
Yes, it is. It just seems to be unnecessarily drawn out, the whole thing. Thanks, Convener.
Okay, thanks. Lindsay, do you want to drop your screen for me? Thanks.
Yeah, that's it.
Thanks very much. Okay, I appreciate we're still waiting for Karen to come back, but I don't think that should stop us being able to go on to discuss the application. Councillor Reynolds, can I maybe give you the opportunity to go first this time?
Okay, Convener. Oh, Karen's back with us.
Oh, Karen.
Hi, sorry, I had to pop off and just check.
That's okay.
We believe that this would be quite low risk, considering we've seen the submissions already, but it's more for the audit trail for any appeals or anybody objecting to this planning permission. So
just getting the wording right.
Yeah, it's getting the wording right and making sure the decision notice refers to all the conditions that they've not met already.
Okay, that's super. Thanks very much for that, Karen. Okay, does that help you, Councillor Reynolds?
It does, well. Yeah. Sorry.
Yeah, no, I was going to say, I mean, I'm happy to start if you prefer, but or I'm more than content if you want to fire away.
No, if you want to continue, and Councillor Cameron, this is a new one for me. As you know, I'm not on planning and I haven't been on many of the LRBs. So, as I said, when I looked at this, I thought, oh, this is just an extension, but you guys know more about that than I do.
That's okay, Councillor Cameron. And in fact, actually, I think seeing some of the pictures today has been quite helpful, because when I glanced at one of the pictures, it looked like from the sort of the diagram, it looked like we're having a side extension, but actually it was just showing it from the side. So, you know, I think, you know, these types of discussions are really helpful. I mean, what we have before us is, to all intents and purposes, is an extension to a previously approved application. However, I understand through the processes that we've had to take it back as a new application. But I think we have to give cognizance to the fact that there is already an approval there, and that, I think, you know, I suppose outweighs the NE2 and the T2 and 3 considerations, because we've already established the principle of a house on this site. For me, I think that I would be content to again to approve the changed house style. In fact, I think it's an improvement. So D1, I think, is actually enhanced in terms of the policy. So, and I think that the glass, the additional glass, will actually reflect the surroundings better than solid, perhaps white walls might have in the past. So for me, I'm content with what has come before us. What I would ask is that we do stick to adding conditions 1, 6 and 7, which I don't think have been satisfied yet, and we make reference and tie in conditions 2, 3, 4 and 5 from the previous application and the information provided there, so that there is a link. And again, Mr. Evans, you can come back with the wording to us as you have done previously on other applications where, you know, the wording for conditions have had to be considered a bit more carefully. But so I think I'll probably just leave it at that. Councillor Reynolds.
Yeah, I'm quite happy with what you've been saying there, Convener.
Okay. Councillor Cameron.
Likewise, and I'm not going to repeat the numbers of the conditions in case I get them wrong and cause confusion. It's fundamentally the conditions that were put on before, but those have already been discharged by report should stand. As you say, Mr. Evans will come back with the correct wording, and we leave the other 3 for them to be discharged. But yes, I'd be happy with that. Thank you very much.
Okay, Mrs. McBain, do you just want to formalise the decision, please?
Thank you, Convener. So members are all in agreement to approve the application conditionally, subject to your agreement after the meeting.
Yeah, so just be the 3 outstanding conditions with a reference to the previous submissions for the other conditions. Okay, so thank you all very much for today. And I'm sure I'll see you all very soon, if not on another LRB. Have a nice holiday, Gavin.
Perhaps.
And I know we'll miss you at the next LRB.
Thanks very much.
Thanks. Can you stop the recording?